And there you have it, folks. The judge has called the afternoon lunch break in the Green Bay, Wisconsin trial of George Burch. He's on trial for first-degree intentional homicide. That's the top charge in the state of Wisconsin. It carries a possible life sentence. The defendant accused of killing a young mother named Nicole Vanderhayden. The defendant is saying that the victim's boyfriend is the real killer. So there's been a real finger-pointing session in this courtroom. To help us break down some of the testimony, Yosha Gunasekera is here along with us on the Law and Crime Network. Yosha, good to see you again.
Thanks. It's great to be here.
So some interesting information came out within the last hour or two in this case. One of the forensic examiners testified that the defendant had searched for information about this case 60-some times between the time she went missing and apparently when they arrested him. That's a lot of searches.
It is a lot of searches. Again, you're going to see this fact try to be spun multiple ways. The prosecution's obviously going to say, you know, that's very curious. He's obviously involved. And the defense is going to say, yes, he was involved. He did have a relationship with her, but he didn't ultimately kill her. He was just interested in finding out what ultimately happened to her.
Well, he claims he knew. The defendant is claiming he was forced to go along with this at gunpoint, with the boyfriend forcing him to go along with it. So, you know, it can clearly be spun, but then, okay, why search for information on it? Why not come forward and say, if that's really what happened, say, I was forced, you need to go check this out right now because this guy has the evidence? Or would they just turn around and say, well, no, he wouldn't do that because he was scared that they wouldn't believe him?
That's likely what the defense is going to do here. They're going to say that he didn't want to come forward because he did have an intimate relationship with the victim, and all fingers are going to suddenly point to him. So he didn't want to come forward. He realized that she had already died, and obviously that's not the moral or right thing to do, but that's how they're going to try to cover that up.
Yeah, this is just becoming a trial about the boyfriend, the forensics. It's like little mini trials around the question of the defendant's guilt or innocence in this case. So, you know, that's one thing. The information about the searches came out, and then the cell phone information came out. And I think that this just gives the state a lot to really argue about. The defendant went from the bar area to the victim's home, basically, to the site where the body was found, to the site where some of the victim's personal possessions and belongings were found, and then he goes back to his house. So if we're to believe the defendant's story here, which is not terribly plausible, where does the boyfriend leave the picture here? If the boyfriend forces the defendant to do all this stuff, and then the defendant just goes back home, you know, not back to the residence where the boyfriend was found. Okay, that piece just falls apart. You get what I'm saying?
Yeah, it's definitely tough. And this is where maybe the defense decides to abandon its story. Remember, the defendant doesn't have to put on any sort of story, any sort of evidence. Really what they might focus on in their case is attacking the reliability of cell phone data. While it does seem like a slam dunk, there are experts across the nation who will testify you can't actually pinpoint an actual place with the cell phone triangulation data, and that's what they should be doing. They should be putting on an expert to say, yes, this looks bad, but can you really trust the data if the story is just getting too out of hand?
One of the better pieces of cross-examination rather that I've seen in this case, and by better I say better than what we've seen previously in this case, but not textbook excellent, was this cross-examination that we just saw of the expert on the stand moments ago. Questions about gaps in his knowledge about how these devices work. They were scripted, but they did make the point that, hey, look, you don't know known error rates. Well, that sounds like they're trying to attack the Daubert introduction of the evidence just to lay a record for an appeals court to come in and say, okay, none of this should have come in at all because the guy that's up there testifying doesn't even know the known error rate, and that's language right straight out of the Daubert case that deals with the introduction of scientific evidence. A good question. Not necessarily something a jury would latch onto. I think the jury would have latched onto the bigger picture, the staccato nature of the cross-examination. Just poking at holes in that expert's knowledge. I don't know this. I don't know that. I can't explain this. I don't know how that works. I think that was effective.
It's a classic line of questioning that defense attorneys do everywhere when there's an expert that doesn't have intimate knowledge, that hasn't worked at Fitbit, that hasn't put the Fitbit together. Seizing on those holes is something that the defense attorney is definitely going to close on, and it's going to be powerful. Again, we haven't seen this type of data in very many cases, and so it's still ripe to really attack the reliability, and one very effective way is to just go after the expert.
I think that had effect, as I said, twofold. One on the appeals court that's going to be reviewing the record, and also on the jury just saying, hey, look, you know, how much can we believe of what this guy just said? But it doesn't erase the questions and the implausibilities in the defendant's story. One other interesting piece of this, the state, and I missed this, I'll admit this, I missed this the first time around. The state spent a lot of time questioning the boyfriend, okay, the guy the defendant says did it, about the types of guns that he had. And the state was able to elicit testimony that the boyfriend just basically had long guns. But he had a concealed carry permit. So something there is not matching up either. And I don't know if the defense exploited that as successfully as the defense could have, because the presumption from the testimony of the boyfriend was there's no way he could have been threatening the defendant to carry out this and go along with it if he didn't have a concealed gun of some sort, which is basically what the defendant alleged against the boyfriend. But then if you don't have one, why do you have a permit for one?
So it's very interesting here, and it's something, again, the defense can close on. If they weren't able to elicit it out of questioning, we so often see the TV and movies where, you know, the cross-examination is where, you know, the suspect just suddenly crumbles or one of the witnesses crumbles, but this is still something they can capitalize on later on. What's really interesting about this entire case is that the state understands the defense's argument. So often the defense is, you know, shrouded in mystery until the prosecution closes. So they really have an advantage here, and they're able to capitalize on that, which is very interesting and something that you don't see often in cases.
Yeah, an interesting case. We have a lot of finger pointing, a lot of forensic evidence that we're trying to make sense of and line up. We'll be back with more live testimony in a little bit more than an hour. In the meantime, we're going to talk when we come back here on the Law and Crime Network about the Larry Nassar case, some new traction in that, and also the Parkland, Florida school shooting. We're going to be analyzing what the Sheriff's Department could or should have done to try to stop that attack. We'll be back in just a moment. Welcome back to Law and Crime, everybody. We're going to switch gears and talk about a case that captivated the attention of an entire nation and in some ways the entire world. That is the case that we covered here on the Law and Crime Network, the lengthy sentencing hearings of former USA gymnastics coach Larry Nassar. He also worked for the University of Michigan. He also was a private doctor who worked with local gymnastics organizations all around the country, including in Michigan. He was sentenced to 175 years in prison in one case, 125 years in prison in a series of other cases, lengthy prison sentences related to the abuse of many, many, many young women. The sentencing hearings resulted in memorable exchanges just like this one.
Thank you. I don't deserve the thanks, you do. And just for the record, since you spoke out, Tom, could you tell me your last name and spell it?
Last name is Brennan, B-R-E-N-N-A-N.
And formally it's Thomas?
Thomas, yes.
Normal spelling?
Mm-hmm.
Thank you very much for being
For
here.
the record, go to hell.
Anything else you'd like to say?
Me?
You. You're here, sir. You spoke out. I'm allowing you an opportunity. You seem to have a few things you want to say. I think the world probably wants to hear, and so do I.
I have a different relationship with Larry from the standpoint that I was a coach for many years. I'm also an exercise physiologist.
Exercise physiologist?
Yes. When I graduated from grad school, he was an advisor of mine. He's been a mentor of mine. I've done clinics with him for years in the past, and I've probably sent well over 100 kids to him over the years. So the guilt I feel for that is hard to fathom. So he didn't only deceive these girls, which is, honest to God, that's the worst of the worst, is what he does to these girls. So they have the voice. But what you did to everybody else who trusted you and sent girls your way is disgusting, reprehensible, unforgivable. That's all I gotta say.
Sir, thank you very much for speaking up. I hear that guilt that you feel, and probably so many referrals to him have the same voice, sentiment that you do. But again, I truly appreciate there not being any blame on anyone. You should not take the blame as well. There is no girl who was assaulted who's blaming you or anybody else. Thankfully, the blame lies solely with defendant.
Mm-hmm. I'm getting that. I appreciate you letting me speak.
Thank you, sir.
It's more about her.
I understand. Next, do we have the three?
We do.
Yosha Gunasekera remains with us here on the Law and Crime Network, local criminal defense attorney. You sat here and watched many of these people speak at the sentencing hearings, and one can understand the anger that this took so long to catch.
Definitely. Having watched so many of these women come forward and their family and their loved ones, I still get goosebumps on my arms just listening to their victim impact statements. They're very, very powerful. They were broadcast nationally, and now, you know, people are taking actions to protect future women and future children.
That's exactly where we're going with this. The reason we're talking about this again, folks, is because the Michigan legislature has decided to act to try to seal up a number of loopholes in state law that many people can say resulted in this abuse going on for years and years and decades. Why wasn't this caught? Well, whenever we have a big issue like this, as an investigative journalist, I sit and look and say there's got to be some gap in the law that is resulting in the system operating this way. So among the things that the Michigan legislature has proposed happen to state law to try to catch people like Larry Nassar is extend the statute of limitations for both civil and criminal sexual child abuse laws and claims. They're trying to extend the statute of limitations to go 30 years past a victim's 18th birthday. That's a long, lengthy, possible period during which someone could come forward and then actually get a case commenced, both civil and criminal.
It's true, and I think for the most part this is an excellent change to the law. My only concern is in cases where we see stranger assaults, because 20, 30 years later, there are issues with, you know, eyewitness reliability. Now, in the Larry Nassar case, it's totally different. These women knew Larry Nassar. They were treated by him. But in stranger assaults, you have to worry about the reliability. And we see in Innocence Project cases that a lot of times we have these DNA exonerations and the wrong person has been jailed. So I think there might need to be some nuances in the law.
Well, one would hope that the constitutional presumption of innocence until proven guilty beyond a reasonable doubt could kick in. I realize that this makes it easier for someone to launch either a civil case or a criminal prosecution, but I would hope that a prosecutor worth his or her weight would look at a case like what you're articulating and say, okay, well, there's no evidence. It took you 30 years to come forward or longer. I don't know if I can, excuse me, I don't know if I can take this case. You know, that might come into play. And if a prosecutor does take a case and there's no evidence, then a jury could acquit.
And that's always the hope. Unfortunately, we see those rare cases that do slip through the cracks and the wrong person is prosecuted. But hopefully this is going to be very powerful for women who were abused as children, felt uncomfortable for the many, many valid reasons of not coming forward immediately. They know their abuser, and then they're able to, when they are ready, to still get justice. I think it's very powerful for those cases.
A couple of the other changes that the legislature is considering here, increasing the penalties for the possession of child pornography to 5 years in prison. That's an increased penalty. Now, keep in mind that a lot of these charges actually were federal charges, and I don't know all of the backstory behind that. Presumably it's because Michigan state law was too weak in that area.
It's interesting. Normally you see with child pornography cases, they're federal cases because often that pornography is crossing state lines.
That's true.
So there's federal jurisdiction here. But it's interesting that the penalty is being increased to 5 years because in comparable states it's much higher. Here in New York, it's a felony and it's punishable depending on someone's criminal history for many years.
So Michigan has really had to take a strong look at its laws here, and the one that I know the most about, because I really dug into this, perhaps you remember me talking about it here on the Law and Crime Network before, are questions about mandatory reporting laws. In many states, everyone is a mandatory reporter. So if someone has some reason to believe, it has to be a good reason to believe. You can't just go report people willy-nilly without having some good reason to believe. But if someone has reason to believe that there is a case of child abuse happening, including child sexual abuse, they have to report it to specific authorities. It's almost always a hotline of some sort. And in many cases, many people have to report. So if a teacher learns that some kind of abuse is going on, not only does the teacher have to report, but then the school principal has to be notified, the school principal has to report. Many states just say everybody's a mandatory reporter, but there were about 12 states that an analysis that I did for lawandcrime.com revealed basically would have allowed enablers such as those alleged to exist in the Larry Nassar case to slip through the cracks. They didn't have to report anything. Well, Michigan is one of these states, and Yosha, after spending hours and hours and hours looking into this and talking to a couple of legislators, 2 of the bills that have been proposed basically seal up this loophole that existed in Michigan and 12 other states. They're saying flat out, people involved, and the bills were just published within the last 10 minutes, so I'm just getting my first look at them now. But individuals who are paid or volunteer to be involved in athletic activities involving K through 12 or college level athletes have to report. This seals up a number of the loopholes that I identified in Michigan law. Bold-faced changes to state law here introduced by a number of senators, also making it clear that mandatory reporting laws apply in the college setting and also not just K through 12 teachers, because it was really unclear under Michigan law whether college professionals had to report. So now you have coaches being covered under these proposals. Now you have other college level employees and faculty having to report, and it also increases the penalty. Michigan didn't have the weakest penalty on the books, but it didn't have the strongest one either. This changes it to a 1-year punishment and a possible $1,000 fine or both for someone who evidence indicates knew about something but failed to report it and failed to stop it. So you have increased reporting requirements under these proposals, increased penalties. And look, I have gotten some blowback from the defense bar saying, look, we don't need to keep increasing criminal statutes, but when it comes to the prevention of sex abuse of children, I would like to think it's an area where there's not a lot of debate.
Yes, I understand the criminalization end. It's just you hope that people will come forward voluntarily. Unfortunately, in Larry Nassar's case, we just don't see that happening. So I think this is important. I think what's very important about this statute is just disseminating the fact, the bill, and if it gets passed, disseminating the responsibilities that people have when you're a mandatory reporter. Now, I was in a situation where I was a mandatory reporter and I got training on how to recognize abuse and how to properly report it. So not only do we want to pass these laws, we want to make sure that people who are going to be reporting the abuse know the proper channels of how to do it, and they're not going to just blame not knowing that this law existed or not knowing that they had this responsibility.
Yeah, this Larry Nassar situation led to so many memorable moments, just so many people harmed coming forward years later testifying about what happened to them. It included moments like this one, which were emotional not only for those who were speaking, but in a couple of rare cases, Larry Nassar himself.
Take your time.
All right, wow.
You're strong.
What have you done? My words are to you, Larry. We both know I've known you basically all of my life. In fact, I've known you 31 of 37 years. And this last year has traumatized me in ways you cannot even begin to imagine, as I've had to realize I was abused for many years of my life. And this, my old friend, is because of you. Initially, and only until recently, I have defended you. I have fought for you. I have believed you. I have had many sleepless, crying, heartbroken nights when this originally broke. I thought they must have misunderstood you. I was standing by you. I shouldn't have, but I did. This isn't something I'm proud of, but as more and more is coming out, I did. I defended you with my whole heart. We believed you looked out for us and protected us from harm. We literally loved you like family. Because we thought you loved us back. I truly never felt one time bad about what you did to me, ever. I trusted you with my body and my life. I trusted you as my doctor, and I trusted you as my friend. I hope you cry like we cry. I hope you feel bad for what you've done. I hope more than anything each day these girls can feel less pain. I hope you want that for us. But this is goodbye to you, Larry. And this time it's time for me to close the door. It's time for me to stand up for these little girls and not stand behind you anymore, Larry. Goodbye, Larry. May God bless your dark, broken soul.
Thank you. Your words echo the sentiments of all of the other survivors.
There was a lot of raw emotion on display in these courtrooms in Michigan during the Larry Nassar sentencing hearings. So right now, the state legislature in Michigan has bills proposing to seal up the gaps in state law that allowed situations like the Larry Nassar situation to go on as long as they did unchecked. We've been talking about them. Yosha, one other change that the legislators are proposing is making it clear that government institutions are not immune from civil liability in cases of sexual assault. The general presumption, as we know it, is that the government can't be sued. There are exceptions, for instance, usually in things like slip and fall and car accidents. You know, if you slip and fall because the post office forgot to shovel the sidewalks, then you can have some damages to recoup your own losses in securing medical care. And if a government agent is driving and does something wrong in traffic and they hit your car, you can have reimbursement for the damage to your car and any medical bills you can face. But in other areas, this becomes a contentious point. And of course, one of the claims that was made here is, well, the university system can't be sued because there's immunity. And so the legislature is turning around and saying, we're going to wipe that off the table right away. University system, you can't hide behind that.
And I love this new proposal because in the Larry Nassar case, you just see egregious acts upon, the university here. They really are continuing to claim that they didn't know about this abuse, even when there were complaints. It's incredible that they're hiding behind this. And I think that this is most important, to go where the money is, because I think that that's where, unfortunately, a lot of the power is. And so holding these institutions much more accountable is going to really lead to real change. It's going to open eyes of maybe the more powerful people here to really hold their staffers, their faculty, and the people who deal with their students accountable.
I agree. Oftentimes it's said that the solution is not necessarily a criminal solution, but an economic solution. And this goes relatively far. It doesn't go as far as Florida does. But a lot of these states are making these universities, they're putting them on notice, making it very clear, hey, look, you want to harbor this, you're at risk of some multi-million-dollar lawsuits. This is going to force administrators to watch their pocketbooks, because sweeping it under the rug can ultimately just result in them causing a bigger issue. They're not going to have the money.
I completely agree. I'm not for the over-criminalization of things. And what's important to know is that in civil and criminal cases, there's different standards. In so many ways, it's easier to go after someone civilly. So I think that really packs a punch. It's really going to wake people up.
Yeah, and looking back at the whole situation here, from my perspective, just look at the sadness that surrounded this. Look at how many people were affected by this. Look at the people who broke down at the podium. Look at the parents who were rightfully so angered at what happened here. But buried in the heartache, it seems to me that the beauty of the American system, and I don't mean to be flip by saying it this way, is that the system can address this and try to change along with it. And that's the process we're looking at right now. We're watching the legislature examine this situation, notice the heartache of so many of those young women, their families, the people that surrounded them, and saying, this will stop. We'll change the system, because that's the way American democracy works. We're going to be back in a couple of minutes to talk about the Parkland, Florida shooting and whether or not the system will change to address that as well. What legal solutions can come out of that tragedy? We'll be back here on the Law and Crime Network in just a moment. Time now on the Law and Crime Network to talk about the Parkland school shooting that happened a couple of weeks ago. You have a young man who's been arrested. He basically admitted, if we're to believe the reports, his role in what happened, Nicholas Cruz. So many people are able to point the finger at him. His own defense team basically saying that they'll agree to a plea right now if the state wants to take the death penalty off the table. That's a situation that the defense and the prosecution needs to try to work out to move that criminal case forward, and whether or not it will deadlock along those lines, and how important a death penalty is to the local residents. That's one issue, but a lot of people are focusing attention and heat on the local sheriff's department. Did the local sheriff do enough to investigate the alleged shooter and to stop what happened as this whole thing unfolded? So, up for discussion now. Accusations that deputies waited outside. There's the local sheriff. He's been taking a lot of heat in the press, on social media, questions about whether or not his school resource officer and others should have gone into the building right away. A lot of factual disputes around this, Yosha. We don't quite know everything yet because the facts are still coming out, but the deputy thought the shooter was outside. That's one of the most recent things that's come out of this. He didn't go into the building because he thought the shooter was outside. Once the actual SWAT team, which is clearly better trained for an active shooter, once the SWAT team showed up, the local school resource officer helped that SWAT team, not only by giving them entrance keys and keys for doors inside the building, but also explaining the layout of the facility. And the local school resource officer also saying, look, I'm not trained to respond to a shooter of this type. It's not what I usually do as a school resource officer. So a lot to discuss here. Should the local sheriff have done more?
I think that there needs to be more training. I think that that's clear. There was a pattern of the sheriff, potentially ignoring this young man who was clearly having some sort of issues. But I think it's all a little bit of a red herring for the bigger issue, which is, gun legislation and access of guns to schools. I feel like there is a conversation that is necessary on whether the sheriff did what he was supposed to, whether the deputies responded appropriately, whether there needs to be training. I think that's an important issue, but I think that is not necessarily where the focus needs to be entirely. I think there needs to be some overarching issues that not only how can we prevent another school shooting like we see in Parkland, but how can we prevent another school shooting anywhere? These are very fact-specific issues to the Parkland shooting, when really we need to be also focusing on the broader issues here.
Yeah, as to whether or not the sheriff's department waited outside improperly, we've analyzed that on lawandcrime.com. We've analyzed whether or not the FBI should have acted. The FBI is saying, well, look, we should have, but here's one of the legal things underneath this. There isn't a duty to act. Sheriff's deputies don't need to do anything. legally, they can't be held accountable if they do nothing. So that's the general presumption here. Parents, victims cannot go sue the local sheriff's department, excuse me, can't sue the FBI for not following up on tips and not acting. That's the baseline legal standard. But there's an exception if there was a special relationship. And a lot of people, a lot of legal commentators are saying, well, that school resource officer had the special relationship because that person was specifically designated as a resource officer, or in some people's opinions, a guard of that particular school. And a failure to act there could trigger liability. It's an exception.
The special relationship issue is very interesting. We often see it in cases of a babysitter or taking care of a minor child, that responsibility that the person has. Now, the question is, did this resource officer actually have responsibility for the student's safety in that way? It appears to be unclear. He wasn't trained to deal with an active shooter, it appears, as what we know now. So I think there could be two sides to the story until we know a little bit more about this resource officer's role in the school.
Yeah, I mean, to say that liability is going to attach is a little bit premature. We know what the standard is. That's the standard. There's no duty, but there is one if there is a special relationship. But then, okay, let's say there could be liability attaching, but does that necessarily mean the guy needs to go run into the building, as the president suggested, when the resource officer who was outside said that he remained outside because he thought the shooter was outside? You know, there's got to be some wiggle room in that standard to say, okay, look, well, you know, chaos is erupting and we're trying to slice and dice and analyze and scrutinize a situation that played out in about 3 minutes. You know, we're taking longer to analyze it just here today than it took to actually play out. 17 people were dead in 3 minutes. Is that enough time for the officer was outside to figure out where the shooter was and then try to decide whether or not it's going to be helpful for him to run in after the person?
Well, the question is, if the police officers there truly believe the active shooter was outside, can you really hold them liable for not running into the school when they actually thought the danger was outside? This is such a case of so much swirling information. Everyone has an opinion on this, and it's just really unclear what the officers on the outside actually knew at the time. And I think that that's going to be very important before delving into the issue of liability.
Excuse me, one of the other issues here that people are talking about is whether or not the local sheriff's department ignored warning signs related to the shooter, Nicholas Cruz. There's been a lot of talk about this issue. I have been sitting here asking myself the question, Yosha, okay, you can say they should have done something, but what could they have done? Some of the ignored warning signs that are floating out there for debate include the following facts that have been released by the sheriff's department. Apparently, this guy slammed his mother during an argument, okay? There were tips that he was said to possess guns, tips that he was also said to have been making verbal threats about the school. There were calls. It's debated how many calls there were. The sheriff says 23 calls. There's some evidence that there were actually 45 calls involving either the shooter or his brother. Maybe the sheriff's number is accurate. Maybe the rest of the 45 calls were about the brother. Going back over a period of 6 years, questions about whether or not these tip callers said the sheriff should go recover the weapons. Okay, well, what legal ground would the sheriff have to stand on to recover the weapons? You can't just go round people up and take their weapons away. There's the Second Amendment.
Exactly. I mean, it's a very complicated issue here. For instance, let's take him throwing his mother against the wall. I mean, maybe that's the grounds for a criminal investigation, potentially criminal charges, but what if she decided she didn't want to move forward? Then really the sheriff's hands are tied.
Exactly. Exactly. I mean, at a base, it's simple battery. Okay, that assuming that Florida follows the bar exam law that we all kind of have to study, the general rule. So that would be the charge. But does the mother want to move forward?
Exactly.
Does the sheriff actually step in and make an arrest?
And so that's the issue. I think people are very angry that he wasn't arrested and thrown in jail, but that's not always as easy as people make it out to be. Really, this was a cry for help by this young man, and maybe there should have been other non-criminal solutions here. Maybe he should have been getting the mental health treatment years ago, and we wouldn't be in that situation.
You decided to raise the issue that I have spent the rest of my research time in the beginning of 2018. Part of it was Larry Nassar, then it's this. Okay, what are they supposed to do with him from a mental health standpoint? Florida law requires a lot. You can't just lock people up in the United States. Let's just sort of start with that. There's a habeas corpus process. Just because somebody is doing some of this stuff does not mean you can go lock them up. And the sheriff has said, hey, look, I reacted to what I could react to. But so many of the people complaining about this are not sitting down saying, okay, what was he supposed to do? As you said, maybe the mother didn't want to press charges. Maybe, in the mental health arena, you can bring somebody in for an examination in Florida, but statistically, not many examinations. It's less than 25% of these examinations, which can roll for a couple of days, result in what's called an involuntary commitment, where someone is forced to remain under lock and key at a mental health facility. In order to get there, it's a complicated legal analysis. It has to be one thing or another, and one thing or another, it's either 1 or 2 or 1 and 1 or 2 and 2, and it basically requires that some threat of violence be imminent. It's a little bit like a stand your ground analysis. They can't lock somebody up for, presumably, if they're following the letter of law, saying, well, I don't know, maybe I will shoot somebody. Well, that's not imminent enough. Now, would a judge broadly read the law to say that's enough to lock somebody up? Maybe, but it could be challenged. So people keep throwing this mental health solution out there, and I've written a couple of pieces on lawandcrime.com. Check them out, because people are saying this is the solution. Well, okay, as the law is written right now, it's not necessarily a solution. And the mental health community is saying that it's very hard for us to predict who is actually going to become violent. I mean, mental health isn't evil intent. It's not suggesting violence. The mental health generally means that someone struggles to get through daily activities. And that's what it really is. It's not evil intent. It's not threatening violence. So to try to put the two together really infuriates the mental health community. There's a lot to unravel here.
Completely. And you are totally right in saying that involuntary commitments are so hard, not just in Florida, but they're hard everywhere to achieve, even, when you're working with an attorney, and for good reason. People who have, mental health issues shouldn't necessarily be locked up and the key thrown away. And so if it's so easily accessible, then you're going to be seeing it as a solution when it just simply isn't appropriate. I think what maybe could have been done earlier is less intensive social services that he could have been provided. I mean, it's so easy to now say removed from the situation, but you do see so many kids in this situation, so many kids who are having these issues, and really it's not appropriate. They're not all going to become future school shooters, and it's not necessarily appropriate for them all to go into this involuntary commitment-like setting.
Yeah, I mean, questions as to what the sheriff should have done. I mean, do they want to change the mental health law in Florida to turn around and say, okay, you utter anything about a school or a mass shooting, then automatically it transitions you to some involuntary mental health treatment? Maybe, but okay, well, the sheriff didn't have that law on the books, and without a law on the books, the sheriff can't act. So some of this criticism of the sheriff has not delved into the next question, the logical question, which is, what should he have done? Good discussion. We're going to transition over to the Burch case. One of the previous witnesses on the stand today really was digging into forensics. 2 witnesses on the stand today, indeed, really digging into the Fitbit data, the cell phone data that came from the defendant's phone. Want to review some of that testimony for you now. We'll be back with more analysis in just a bit.
Sergeant Lopnow, with respect to the Fitbit data, were you asked to do any further analysis on that data yourself and comparing it to known samples of Mr. Dietrich's activity?
Yes, I was. We had the videotape interviews of Mr. Dietrich, in which he is on video with his Fitbit on his wrist. So I was asked to compare the data that we received from Fitbit to what was viewed in those videos.
Can you describe for the jury how you went about doing that?
I had the copy of the video. I guess to give you an example, I have two screens on my computer, so I had the video on one screen and I had the Excel spreadsheet of the Fitbit data on the other screen, so I was comparing them side by side.
The Excel spreadsheet of the Fitbit data, how is that organized?
There's several spreadsheets within that document. The one I used to compare was labeled steps by minute. So for example, there's also a spreadsheet in that document labeled distance by minute, I believe, and a couple other ones, but I used the one detailing the steps recorded per minute.
So really what you were interested in is comparing the number of steps on the Fitbit report to the number of steps that you were able to potentially observe Mr. Dietrich taking on the videos that you were watching.
Yes, that's correct.
When you received the information from Fitbit, was that initially in UTC or was that in Central Standard Time?
I believe it was Central Standard Time.
And were you able to adequately come to a conclusion about the accuracy of that data based on looking at it and comparing it to the known data on the video?
Yes, I was.
Did you watch the entirety of Mr. Dietrich's recorded interviews?
I did.
And those were two separate recorded interviews, is that correct?
Yes, the first interview by Sergeant Holschbach with her initial interview of Doug at his residence, as well as a follow-up interview at the Sheriff's Office by Detective Kingston and Deputy Caters.
And the first interview at Mr. Dietrich's house, how long was that interview?
I believe it was about 2 hours.
So you were able to view minute by minute Mr. Dietrich's activities and compare them to each minute of the recorded activities from Fitbit?
Yes, I was.
And the interview again at the Sheriff's Office, how long was that?
About 3 hours.
And were you able to do the same thing with respect to that data, compare the information minute by minute from Fitbit to your minute by minute observations of Mr. Dietrich's activities?
Yes, I did.
Is it fair to say that during large portions of each of those videos, there is no activity by Mr. Dietrich, other than he's seated or not moving?
Yes.
And when Mr. Dietrich is seated or not moving, what is the Fitbit registering?
It's registering that there are no steps being taken.
And that is reported in minute by minute data?
Yes.
0 steps per minute?
Yes.
Did you note any instances where Mr. Dietrich was not moving, but the Fitbit was registering activity?
There was a couple instances. One I recall during the initial interview by Sergeant Steffens at his residence, he pulls his phone out of his pocket. You can see his hands moving. He's not necessarily taking steps, but he's showing Sergeant Holschbach the phone. At that point, there are several steps recorded. Also, I remember in the interview at the Sheriff's Office, there are times when he begins talking with his hands. So he's still seated, but he's moving his hands quite a bit. And at that point, there are some steps registered.
Out of the 300 individual minutes that you noted, how many times did you observe a discrepancy between Mr. Dietrich not actually taking steps where you observed the Fitbit registering steps?
I believe there was about 3 times I observed that. And in those cases, he was moving his hands, but not necessarily moving his feet or taking steps.
Where is the Fitbit device affixed to his body, if you could observe it?
It was on his left wrist.
So it actually registers wrist movement, correct?
Correct.
In addition, were there instances where you could observe Mr. Dietrich taking steps where the device was not registering any activity?
There was a couple instances of that. I believe in the initial interview by Sergeant Holschbach, there was times when he was seated in close proximity to where she was sitting when they were completing a written statement. He does lean forward and get up to show her a phone. I believe that happened once or twice where no steps were registered. In reviewing the video, he's leaning forward from, I believe it was a bar stool in the kitchen and leaning and taking, stepping towards her to show her the phone, but not taking steps, so to speak, or making any jerky movements.
And that's a situation where Mr. Dietrich may have taken 1 or 2 steps forward, but the device did not register any activity.
Yes.
And you said that happened on 2 or 3 occasions in that video?
I believe it was once or twice in that video, and then in the video from the sheriff's office in his follow-up interview, there was a couple of occasions where he actually stood up, took a drink of his beverage, I believe, stretched, and then sat down. So at that point, no steps were recorded. I believe there was also another instance where he got up to stretch and slowly paced a little bit in the interview room, and that also did not record any steps.
Sergeant Lochnow, I just want to focus on this Fitbit data a little bit. So you said that you were able to watch the videos that were available to the Brown County Sheriff's Office of Doug Dietrich, correct?
Yes.
And you said it was about 2 hours on May 21st and 3 hours on May 22nd?
If I remember correctly, yes.
So I know lawyers are pretty bad at math, but I'm going to try to do this. So as the state was saying, the minutes you were able to watch, that also means that, so there's 22 hours that you weren't able to identify any sort of Fitbit data and compare it to what Doug Dietrich was actually doing on video, correct?
Can you clarify what you're asking?
So you watched 2 hours on May 21st? 2 hours
Yes.
of video?
Correct.
And there's 22 hours of time that you didn't watch?
That's correct. For this report, I was specifically comparing the data to the times that were on record that we had recorded.
So then just to put it in terms of minutes, that's 1,320 minutes of time that you yourself did not watch.
That's possible. I would need a calculator to confirm that.
Me too. And then same thing on May 22nd. So there's 3 hours you watched, but that also means that there's 21 hours that you don't have accounted for, correct?
Correct.
So then that's 1,260 minutes.
Again,
or around there.
Yes, very possible, yes.
So in total, that's 2,580 or right around there minutes that you didn't watch yourself.
Again, I can't give you exact numbers, but approximately, yes.
And you said that there was some errors in the Fitbit data, but they were minor in your opinion?
There were those small inconsistencies, as we discussed, in watching the video compared to those times when it did record a couple steps. Mr. Dietrich is seen moving his hands at that time with the Fitbit on his wrist. A couple instances also, as we discussed, when he was taking steps, a couple steps, there wasn't a lot of motion. There were very slow movements, and at that time it did not record.
So those were errors in the data, albeit minor?
Yes.
And then I know you're trying to explain why those errors didn't happen. Do you have the technological background to be able to diagnose those errors? Or is
No.
that just your lay opinion on it?
I'm describing what I viewed in the video compared to the records, just that.
Okay. Do you have a background in technology where you can tell us how a Fitbit operates?
No, I don't.
Can you tell us how the Fitbit app operates?
No, I can't.
Okay. Sergeant Now, I then want to just back up with you further than what the state did. Back in June, you had returned from Madison, and you were still the lead investigator in this case, correct? Or a co-lead investigator?
Yeah, at that time, Sergeant Slinger had officially taken that lead role.
And on June 3rd, you obtained a search warrant to download the data of Doug Dietrich's phone?
Yes, I believe so.
And Doug Dietrich's phone was a Samsung Galaxy S4, correct?
I believe it was.
And his phone number was 920-621-0593?
I don't recall that specifically.
If I show you your report, will that refresh your memory?
Yes, it would. That is the number listed for Douglas Dietrich's contact information in our report management system.
Thank you. And then did you execute that search warrant?
Yes, I did.
And can you describe how that process worked?
After having the search warrant approved, the phone was turned over to crime analyst Tyler Bailing, and he performed an extraction of the phone at that time.
And then that extraction would have been put into evidence at the Brown County Sheriff's Office?
Yes.
And then it's stored pretty much there throughout the course of the investigation?
It's in evidence. I believe Tyler also keeps working copies for review.
And then that information would eventually be sent to the defense as part of discovery?
I believe it would, yes.
And then in July and September, did you also collect DNA samples from Adam Kolpak and Matt Wazenberg?
Yes, I believe I did.
And they gave you consent to take those DNA samples?
Yes.
So some of the forensic data on trial in and of itself in the George Burch case out of Green Bay, Wisconsin, the case of a defendant who says a boyfriend is the real killer. He's trying to point the finger at somebody else. It all has to do with the death of a young mother named Nicole Vanderheiden. So ultimately, some of the testimony from this morning about whether or not the Fitbit worn by the boyfriend, again, not the guy on trial, but the boyfriend, the guy that the defendant says did it, questions about whether or not that data, A, proves that the boyfriend was not involved based on the number of steps, the physical activity, etc. Questions about whether or not it proves that, and questions about whether or not it's accurate. And so we've got a couple of legal issues that we have to split up here, Yosha. If it's not accurate, then an appeals court can look at this and say this trial was a mess, rip the whole carpet up and make it go back to trial.
Exactly. It really depends on the credibility of the Fitbit information. And again, because we've seen it in so few cases nationwide, it's hard to determine whether this data is actually accurate. And it really brings up the question, who needs to testify to the Fitbit data in court? Do Fitbit individuals, people who work there, people who made the Fitbit, is that the standard that we need to have in these trials? Do we need to have those people testify as to the inner workings? And I think there's going to be a lot of people who say maybe yes, because of potential confrontation clause issues.
You know, look at the way cell phone testimony has progressed as we've moved through cell phone technology. It used to be that the cell phone companies had to cough up an expert or at least a records custodian in almost every single case that was covered. Now, a lot of times they just dump it to the local police department and make the local police department bear the cost of getting someone to at least explain it on the front end. And then a defense attorney may call someone else or just try to cross-examine the local authority figure who is reviewing the data. So that's changed a lot. But Fitbit's a different animal. And what we're seeing thus far in the prosecution's case is just the local police department's computer experts trying to make sense of this technology, but they're getting hit on cross-examination because it's an unfamiliar technology. It's not like your standard old iPhone, smartphone, PC, whatever you want to call it, computer data dump that these guys do in their sleep. This is different.
Exactly, and that's what the defense really needs to capitalize on. They need to speak to the jurors and say, do you feel comfortable convicting someone on data and evidence that is not yet proven, that we don't know its reliability? And that's why it's so important that when these experts are on the stand in the prosecution's case, that they poke those holes anywhere they can and really point out where these experts are not familiar with the Fitbit data.
And again, we're also trying to prove a negative here. They're trying to use this data to prove the boyfriend wasn't involved. Look, they have other evidence against George Burch, so I expect the prosecutors to say, hey, look, even if you're uneasy about this Fitbit data, we think that it helps. But even if you go back to that jury room and you want to dismiss all that Fitbit data out of hand, you can still convict George Burch because he's the guy that's really on trial here. I know that this looks like a trial against the boyfriend, but it's really not. It's George Burch who's on trial. And Burch admitted that he was involved in a lot of these acts. He just claims that he was under some kind of duress. You know, you can still convict him based on everything else and then discount his story as a lie he tried to cook up to try to get out of trouble.
And that's where it's very interesting that all of this Fitbit data about Dietrich, the boyfriend, is actually allowed to come in, because it's very easy to forget that it's actually not his trial. It's George Burch's trial. So I think it's an interesting decision that the judge allowed as much in as possible, because it's really the the state here trying to anticipate the defense's argument.
Yeah, really interesting. For those Making a Murderer fans who have stuck with us all this time, another interesting point in Wisconsin, years ago, all of the Fitbit data would have come in and the jury would have had to sort through it. That's because Wisconsin had a very wide open evidence standard for technical data. You saw it in the EDTA tests in the Stephen Avery case, where that just basically went in front of the jury and the jury had to decide whether or not it was good data or bad data. Well, since then, and ironically, not because of the Stephen Avery case, it was at the behest of the insurance industry, Wisconsin decided to move along and pick up the Daubert standard, which is the federal standard that about half of the states, or at this point it may be more states, follow, where there has to be some scientific reliability in the evidence. That's why only part of the Fitbit data is coming into this case. The data about the boyfriend Dietrich's movements came in, but not the data about whether or not he was sleeping, because apparently the device can tell when it's moving, but is not good at figuring out whether someone wearing it is asleep or just sitting on the couch doing nothing or whatever. So there's some unreliability in that data. So the judge kept the sleep data out, but kept the movement data in. Interesting. If this trial had been held 10 years ago, it all would have been in. So that's how evidence law sorts out what comes in and out of a case, and we watch that law evolve along with the trials we cover. So let's continue listening to some of the previous testimony from today in the George Burch case. Again, we should be back with live testimony about 10 minutes from now. But in the meantime, we had another forensic examiner testifying about the defendant's cell phone, where it was and where it moved. Let's review some of that now.
When a phone is powered off or shut off, is there an entry that you're able to locate using the Cellbrite program to see if a phone is powered off?
If the phone is powered off by the user, that would create a log entry that the device was powered down.
If the phone is not manually powered off, but rather runs out of battery life, is that an activity that is logged in the Cellbrite program?
That would not be logged, as the operating system of the device doesn't have the opportunity to create that log as the battery dies.
Were you able to observe Nikki's phone being manually shut off in the early morning hours on May 21st of 2016?
I was not.
You were also indicated earlier that on May 22nd of 2016 you were asked to analyze Doug Dietrich's cell phone. Is that correct?
That's correct.
And again, what sort of information are you looking for in your analysis of Doug Dietrich's cell phone?
Again, the initial investigation of that device would be anything within the time frame of the night of the 20th into the early morning hours of the 21st, whether it be calls, texts, any activity that would have occurred on that device.
And did you also look for activity that occurred throughout the day on the 21st prior to the receipt of the phone?
Yes, we did.
Were you looking for call logs with respect to Mr. Dietrich?
Yes.
Text messages?
Correct.
Any other type of messaging or communication system information?
Correct.
So emails?
Yes.
Facebook Messenger?
Yes.
Did you observe any of those types of activities, calls,
Yes.
messages, and Facebook activity?
Yes.
And you provided your observations to the investigators?
That's correct.
Now, were you asked to actually analyze the report yourself, or did you give the report to the investigators to have them look at it?
I would have created a copy of the report for them to review, but then I would also conduct my own analysis on that data.
Are there occasions where you do simply turn over the report to law enforcement or officers and have them look at it?
Yes.
But in this particular instance, in addition to turning over a copy, you conducted an analysis yourself?
That's correct.
With respect to Doug Dietrich's phone, were you able to note the last time that any activity was logged in the early morning hours of May 21st of 2016?
Yes, I was.
And what was that last activity?
I believe it was a Facebook call or message at approximately 3:07 a.m.
Do you know the party to whom that message was sent?
I believe it was sent to Dallas Kennedy.
And again, with respect to a manual power off, if the phone had been manually powered off, is that something that would have logged on Cellbrite?
Yes, it is.
Did you note a manual power off on Doug Dietrich's phone in the early morning hours of May 21st, 2016?
I did not.
So, for example, if Mr. Dietrich was utilizing his computer to send messages or emails on an account to which he was logged in on the phone, and he was doing that during a time period that the phone was powered off. When he powers the phone back on, you're able to actually use the phone itself to collect data that was sent using a different device.
That's correct.
So for example, if Mr. Dietrich testified that he sent messages using a computer device at 11 a.m., we know his phone wasn't on until 2:42 p.m. Using your phone analysis, you're actually still able to see the data that he sent using the computer.
That's correct.
So in fact, were you able to observe that Mr. Dietrich was affirmatively engaging in messaging activity on his computer during a time when his phone was powered off?
Yes, I was.
And what types of messages or communication was Mr. Dietrich engaging in the early morning or in the morning hours of May 21st of 2016?
Facebook Messenger.
So he was using that application using another device?
Yes.
And I guess I used the term app earlier also. Can you explain for the jury what an app is?
An app is short for application or a piece of software that you would download to put on your device or phone.
What are some common communication applications?
Facebook Messenger, Kik, WhatsApp. Most people are familiar with iMessage. It comes standard on an iPhone.
So in terms of your observations, and I'm not asking you for specific content, but is it true that in the late morning hours of May 21st of 2016 that Mr. Dietrich is engaging in messaging to various parties, Dallas Kennedy, Heather Meyer, in an attempt to locate Nikki?
That's correct.
And you're able to observe those communications that were sent from another device?
That's correct.
And then you indicated at about 2:42 p.m., that's when the phone was manually powered on, correct?
That's correct.
Are there messages that he's sending to individuals that are consistent with the phone then being powered on in that time frame?
That's correct.
And is it fair to say that once that phone is powered on at 2:42 p.m., there is then a flurry of activity on that phone that it appears to be an attempt to locate Nicole?
That is correct.
And after 2:42 p.m. is the first time that you see any flurry of activity sent from the phone itself, correct?
That's correct.
And this is something, again, you prepared?
Yes, it is.
In terms of the numbers, the numbers of steps, you have, I think, 0 through 120 listed. Did you select the number in terms of how high you needed to go?
I did not.
Okay.
That's automatically generated by Excel when you create this chart.
And if Mr. Dietrich had taken, so you used Excel to generate this?
That's correct.
That's a program you're familiar with and use regularly? If Mr. Dietrich had in fact taken more steps in any particular minute, if he was running and took 200 steps in a minute, the graph automatically would have increased that higher number?
That's correct.
So while we see spikes, those spikes are based on the number of steps taken, not based on any other extraneous factor?
That's correct.
And then if I could view 166. Mr. Mailing, is what's displayed on the screen, we're actually going to reduce the size a little bit. On 166, are there numbers on the left side of the graph that indicate the number of steps in the exhibit in front of you? Okay. Your Honor, that was not displaying on there, so we're attempting to reduce the size of the visual so that the numbers display.
That's fine. It's just a different version of 166 for the record, right? Just for the record, what's being shown now on the screen is still the 166 is just an expanded version of that graph showing the numbers on the left. Is that right?
The 166 is as the form that Mr. Veiling can view now. What was displayed up there earlier was expanded too much so that you couldn't see the numbers. What's now displayed actually does include the entire exhibit. And then, Mr. Bailey, what we were talking about in terms of the number of steps before on this particular graph from 2:30 a.m. to 6:30 a.m. on May 21st of 2016, we'll actually note that the graph tops out at 60 steps. Is that correct?
That's correct.
And that's because essentially at no point during that time frame does Mr. Dietrich have more than 50 steps in any minute.
That's correct.
So the graph could be compressed.
That's correct.
And then this displays his activity on the far left at 2:30 in the morning until the far right 6:30 a.m. Is that accurate?
That's accurate.
I'm going to ask you to use a pointer here because I know the times are actually pretty small. I don't know that the jury can actually sitting observe the times. Could you point to the last time that Mr. Dietrich's Fitbit is registering steps before 3:10 a.m.? Right here. And roughly what time is the last? Is that
308, between 308 and 309.
And then between that time frame and 6 in the morning, are there any instances where Mr. Dietrich is registering steps according to that data?
There are at approximately 4:18 a.m. Right here.
And about how many steps is it registering at that time?
Roughly 12.
Analyst Bailing, does the demonstrative video that was just shown accurately reflect the video that you created?
Yes, it does.
At some point in time, there was an indicator in there that you could see Mr. Dietrich's Fitbit. Were you able to view that on the video?
Yes, I was.
Did you watch through later in the video where he actually pulls up his sleeves and you're able to take an even more clear look at that Fitbit on his hand?
Yes, I did.
Do you recall which interview room that was at the Brown County Sheriff's Office?
I believe it was room 3.
Do you know how far it is from room 3 to the bathroom?
I don't.
Is that in pretty close proximity to the restroom?
It is.
And did he, you recall in the sound of the video, did Mr. Dietrich actually ask to go use the restroom?
Yes, he did.
How is the layout there in front of the interview rooms and the bathroom? What is the layout of the Sheriff's Office there?
It's a hallway.
Does the hallway extend in both directions, not just to the bathroom, but further down?
That's correct.
Obviously, do you have any specific knowledge of where Mr. Dietrich went when he was off the video?
I do not.
In addition to your work assisting with the Fitbit, did you at some point later in this investigation become involved in downloading and analyzing additional phones subsequent to the arrest of George Burch?
Yes, I did.
And actually, even, I guess, prior to Mr. Burch's arrest, when the Sheriff's Office became aware of Mr. Burch, were you provided with a copy of a download of Mr. Burch's phone that had been done by the Green Bay Police Department?
Yes, I was.
Were you asked to analyze that download?
Yes, I was.
And was that done by Green Bay PD in a software that you were familiar with?
Yes.
Was it also Cellbrite?
Yes, it was.
What were you looking for when you were analyzing the download of Mr. Burch's phone?
Initially, we were looking for anything in the time frame of the night of the 20th into the morning hours of the 21st, whether it be calls, texts, internet history, any kind of location data available from that device.
First of all, internet history. Did you actually view internet history on Mr. Burch's phone from the time frame of this homicide?
Yes, I did.
Was there anything of note?
There was repeated visits to articles in regards to this case.
When you say repeated, do you know approximately how many times Mr. Burch looked up information on this case shortly after it happened?
About 64.
Now, when you talk about internet browser history, can you describe a little bit about what that is?
Yes, so the internet browser on a phone allows you to go and visit websites that are on the internet.
And when you see browser history, what are you actually viewing? Is that sites that were viewed? Are you actually seeing what he's actively searching? What is the...
You will see the link that was accessed along with the date and time that it was accessed, along with if there's a heading to the website, such as the article title, that would all be viewed in the Celebrate report.
Does each of those links that's viewed represent a separate click or a separate view on that particular page?
It does.
From your standpoint, how easy or difficult is it for you to process the information that is provided to you by Google?
It's relatively simple.
How did you do that?
I used Google Earth software just to input the latitude and longitude coordinates of those specific locates.
As you were using that software to analyze the data on Mr. Burch's phone, did you locate any information of interest relative to his phone's locations during the relevant time period?
Yes, I did.
What did you observe?
I observed Mr. Burch's phone being at a bar on South Broadway. I observed Mr. Burch's phone traveling south down Broadway into De Pere. I observed Mr. Burch's phone traveling to Ms. Vanderheyden's residence on Berkeley. I observed Mr. Burch's phone traveling to the site where the body was found. I observed Mr. Burch's phone leaving the site where the body was found and traveling west on 172 and ultimately ending up back at his residence on Greenwood.
And you noted the locations of the observations. Did you also note that the times of the locations of those phones were consistent with the known time frame of Nicole Vanderheyden's disappearance and death?
Yes, I did.
Were you able to plot those points on a map and again create a demonstrative or a series of demonstratives using the data set that was provided to you by Google?
Yes, I was.
And what form did that demonstrative take?
It is a playable video showing the locations provided from Google and their associated times.
we are once again watching a map that has plotted out the locations where the defendant's cell phone indicated he was, and we're seeing the arrows on the map, including that location right there at the Highway 172 and Highway GV intersection, where the victim's personal belongings were found. So Yosha Gunasekera remains with us here at the Law and Crime Network. What's interesting to me, Yosha, is that the defendant was a relative newcomer to the Green Bay area, and having lived there for a couple of years, it seems like a lot of the things that involve this particular crime happened in areas that are relatively well-traveled areas, not the sort of, you know, secret hiding places that somebody who's lived there for 5, 20, 30 years would know. You know, that highway intersection is one of the most busy intersections or on-ramp, off-ramps to Highway 172 because you can go across the river, you can go to the airport. Okay, Highway 172 basically connects the east and west sides. The airport's on one side, and the other side takes you to Interstate 43, where you can go to Milwaukee. So it's a very well-traveled area, and that's where her personal belongings were found.
So this is further fuel for the prosecution to capitalize on, to point their finger at Burch and not Dietrich. I mean, Dietrich lives in the area. If he were to kill his girlfriend and then dispose of, you know, her body and things relating to the crime, you would think that he would go to less traveled places, versus Burch, who is, as you said, a relative newcomer. And so that's going to be difficult for the defense to kind of explain away.
Yeah, there are, you know, and there have been other crimes where things have been found in this area because it's sort of on the fringe. You know, you've got the Bay of Green Bay, and then you've got the older part of the city of Green Bay, and then this is sort of where all the new development hits the farm fields. A lot of new development in this area, new houses, and not surprisingly, it's where the victim and her boyfriend lived. Again, his family was involved in the construction industry up there. You know, so they may have been building homes in that area. That wouldn't surprise me. A lot of younger people live in that area as well, because a lot of apartments, a lot of new homes, people who are just starting families tending to move in that part of the area. It's southeastern side of the city of Green Bay, a couple of suburbs, you know, Alloway, Ashwaubenon, well, Ashwaubonon's on the other side, but De Pere, then you get Ledgeview, and then that's where all of this was found. So, you know, it's sort of interesting to plot out what was going on here relative to the people involved and the defendant. I agree with your analysis that if it was the boyfriend, he probably would have known other places to try to dispose of the evidence.
And the jurors are going to pick up this locations and, you know, what we're talking about in the same way that you, as a former local, are picking up.
Local for 3 years, yeah.
And so that's what makes this case very interesting, because they are going to use their personal knowledge, and whether this is explicitly stated, they're going to think, hey, this is a very strange place to put a body. It's not somewhere that Dietrich would put it. Maybe it's somewhere where Burch, who doesn't understand the lay of the land, would place a body.
Yeah, it's just another one of these things that you know, could play into you know, the jurors. Green Bay is not a very transient place. Not a lot of people come and go. You know, people in the medical community, journalists like myself come and go. Not members of the Green Bay Packers come and go, but it's not like Minneapolis. It's not like Madison, a big college town where there are a lot of outsiders who come and go constantly. Green Bay's local. It's a little bit more parochial in that sense. So, you know, another little interesting piece of this. We are preparing for court to resume. The courtroom is starting to sort of come back alive here after a little bit longer than an hour, 15-minute lunch break. It looks like they've been at it for about an hour and a half for a lunch break in this case. So we're expecting live testimony to pick up any moment now in the George Burch case. Keep in mind, we have first-degree intentional homicide as the charge here. It's the top charge in the state of Wisconsin. It basically requires a prosecutor to prove intent, but it does not require premeditation or anything like that. So it's interesting, Yosha, because in a lot of states, the top charge would involve premeditation or something like that. But first-degree murder charges, first-degree intentional homicide cases in Wisconsin are relatively easy to prove. You just have to prove that the defendant was there and intended to seek the death or result in the death of the victim. And if the prosecutor can prove that, it's a conviction and it's a life sentence.
It's going to be interesting to see if Burch actually does testify, because they may be able to shore up the intent portion. So it's going to be interesting what Burch is going to say, if he's going to testify, and how that's going to play out.
While we're waiting for court to resume, let's go back and review some more of the previous testimony in this case. It looks like they're taking a little bit longer than we expected to get things moving after a lengthy lunch.